24R00553OM, City of Royal Oak versus Jonathan McCall.
Ryan Clues on behalf of the City of Royal Oak.
Oh, you're muted, Mr. Angot.
Get it right. John Angot appearing on behalf of Mr. McCall as co-counsel.
Melissa Crosscroft also on behalf of Mr. McCall, Your Honor.
Mr. McCall, your first and last name?
Jonathan McCall.
All right, this is the date and time set for a pretrial here that the court had set late last week. I appreciate everybody getting logged in here on short notice. Mr. McCall is appearing by audio only, having some issues with his connection to get video and audio going. Does anybody have any objection to Mr. McCall continuing with this audio only phone call?
No, Your Honor.
Oh, Your Honor.
Not from me, Judge, but I guess I would ask the court to inquire of Mr. McCall, and I know you probably were going to.
Mr. McCall, are you okay proceeding with just the audio connection here today, given the difficulties with your audio video connection?
I'd rather do everything in person, but my opinions don't seem to matter to the court, so it's whatever's it's just whatever you guys decide apparently.
Well, okay. Actually, I didn't know that you wanted that request. I'd certainly proceed with in-person hearings in the future, given that request. I didn't realize that you had that desire. I thought that you wanted to continue with Zoom, but I'll keep that in mind moving forward here. So this is the date set for a pretrial. Couple of things. The court was in receipt of a letter from a Todd Nadeau, a clinical director at Performance Psychology. Defense counsel, have you seen and reviewed that letter?
Yes, Your Honor.
Yes, Your Honor.
And I asked my staff to forward that to Mr. Klusny. Mr. Klusny, did you get a chance to look at that?
Yeah, I did get it, I believe late this morning, Judge.
Okay, so it clearly indicates some ongoing mental health treatment that Mr. McCall is undergoing. I won't go into the specifics, but just to say that it does put into writing the statements and representations that Mr. McCall made at the last hearing.
Right away, you can feel the tension in this hearing. What starts as a routine pretrial quickly turns into something much bigger. The judge isn't discussing evidence yet. He's questioning something far more fundamental: whether the defendant is mentally competent to stand trial. And that's not a small issue. In the American legal system, if a defendant is not considered competent, the entire case can pause until that question is resolved.
So I've reviewed that. The court brought everybody in today, though, because after our hearing late last week, the court had a chance to kind of further consider the arguments and the statements that Mr. McCall had made on the record. That prompted some concern about Mr. McCall's ability to understand the nature and object of the proceedings that are going on against him here in this case, and his ability to assist in his defense in a rational manner. Because of those concerns, the court did look into some of the past correspondence that Mr. McCall had sent the court over these many months while this case has been pending. And that brought up further concerns to those 2 points that I had just stated. Mr. McCall has continually seemed to talk about some coordination efforts between different government agencies here at the city, the court, the police department. Seems to be linking some of the past things that have occurred with Mr. McCall and those agencies into this proceeding. Things that just, again, concern the court enough to where I think at this point it is appropriate that the court refer a competency evaluation here for Mr. McCall. So that's what the court is going to do on its own.
This is the moment everything shifts. The judge says that after reviewing McCall's statements and written communications, he's concerned about McCall's ability to understand the proceedings and assist in his own defense. That's the two-part test courts use for competency. And once a judge starts questioning competency, the law almost forces their hand. Even if the defense disagrees, the court may still order a psychiatric evaluation just to be sure.
Go ahead, Mr. McCall.
So you're trying to take me into custody for stating the facts of what happened inside of the hospital.
Mr. McCall, you are not going
to take me into
nothing is
okay. Well, take me into a competency exam. Extend this even further when this. The thing is that you know, if I am incompetent, it's because of racism and discrimination. If you have a moment, or if you will, if there is a sign of me acting maybe out of myself, it's because of racism, discrimination, and being assaulted. It's offensive. I don't feel I need to go inside a center. I don't feel I need to even sit down and speak with anyone regarding this.
No,
These things. These things are established fact. May I finish, please, Judge, Your Honor? These things are established fact. What I've stated. I'm not going to sit and lie to you. I'm not going to sit and pull something out of left field, right field, ball it all up and say, hey, that looks good, and throw it to the court. What I've spoken is true. And to go through this, to have my word to be, you know, shot down when I've been a law-abiding citizen, I've had no issues with the law. I'm 47 years old. Haven't had any issues with the law outside of them placing their hands on me when they shouldn't have. I haven't had any issues with any people outside of them placing their hands on me when they shouldn't have. I'm not out beating anybody up. I was a CPL holder, a lawful gun owner, and all of these things are being made to look a certain way so it looks good for one side or one group, and we know what side and what group that is, and to make it look bad on me. If this is what's going to go on, I'll just excuse myself from this proceeding and go ahead and, because I am with the, you know, I'll excuse myself from this one, and then I'll speak with the Attorney General for the state of Michigan, go back to Washington, speak to the Attorney General.
Now you can hear just how strongly McCall feels about this decision. From his perspective, this isn't about mental health at all. He believes the system is dismissing his claims and labeling him unstable instead of listening to what he says actually happened. And moments like this are why competency hearings can be so emotionally charged. Because to a defendant, being told you might not be mentally competent can feel like the court is questioning your credibility, your judgment, even your identity.
And I know it's greater than me being perceived to be treated in that manner. As I'm 47 years old, I've had an experience with it over 45 plus years.
All right,
I learned certain words in kindergarten and in elementary and preschool that most kids today don't learn until they're much older. And it wasn't from my family.
Mr. McCall,
Let's
I'm going to end with this, Mr. McCall.
Here's the thing, Judge. Judge, here's the thing. I'm not a bad guy, and I'm not the bad guy in this. So I want a competency exam on every police officer that sat there and lied and said that I've threatened to kill 3 police officers, which kind of front-loaded this thing to get another judge to say, oh, we need to take away his rifles. Oh, we need to do this so we can gain entrance into the home, which they were already going in and going through the thing. So the only entities that were involved with this that I've stated from the beginning, Oakland County Sheriff, Royal Oaks Police Department, and you can also include the City of Detroit and also the Beaumont Hospital staff. That's the only one, which are some of the City of Detroit police officers. But that's the only people I've said. I'm not reaching out of left field. I find it offensive. I find it unacceptable. I find it, it's egregious. It's disgusting that I've got to go through this. Hey, the sky's blue. Well, we don't know. I think you need a competency exam. The sky's blue and has white clouds. Well, I don't know. We need to look at this. The sky's blue. Okay, it's storming. The sky's green. The sky's gray. Oh, we don't know. We don't think so. You're not going to take my word for anything, but you're going to take the word of those lying peace officers.
Yeah,
you guys take that word. Hold on, sir. Please hold on.
I'm going to give you another couple minutes here, Mr. McCoy. But
that's fine. I'll wrap it up quickly, sir. I'll wrap it up quickly. But like I said, you take the words of these officers, that attorney who doesn't know anything regarding me or regarding this situation or regarding this case. No one has looked at the facts of the statements that I've made. No one looked at the letter from CPS. No one looked at the investigation from CPS. No one looked at the investigation or the letter that my wife wrote that I had. People wrote letters stating of what happened that night. I asked a white woman to leave my house over 10 times. If you don't leave, please just step outside to calm everything down. But please just step outside. And here I am, 8 months later. I didn't put my hands on anybody, didn't spit, kick, punch, intimidate. I didn't do anything. And I'm sitting here going through this. Oh, we think you need a competency exam now. So what's that going to do? That's going to take the stuff you guys played, your officers lied and put stuff out there to the newspapers and all these groups, armed standoff. Well, Mr. McCall didn't have a gun in his hand. Barricaded gunman. Mr. McCall didn't barricade himself in that house. I'm not afraid of now one of you. I went outside and talked to the man. I talked to the police. I talked to your officers. The police officer, I believe it was Kaufman, or his last name starts with a K, the one that tried to break down my door unlawfully. That one I did. I told him to get the heck off.
McCall clearly believes the entire case started from false accusations by police officers. He repeatedly insists he never threatened anyone, never assaulted anyone, and that the narrative being presented about him is simply wrong. What's interesting here is that the judge keeps trying to redirect the conversation. The court says this competency question isn't about the facts of the case yet. It's about how McCall is communicating and responding during the legal process itself.
And I believe it's MCR 6.125 and MCL 330.2020 at sec. The statute itself covering the reasons why the court may on its own require this type of competency examination. It seems to be a two-pronged test. One being that the defendant is determined incompetent to stand trial only if he is, one, incapable because of his mental condition of understanding the nature and object of the proceedings. Judge, I would argue, and I think Ms. Krauskopf would agree, Mr. McCall has a full understanding of the nature and objects of the proceedings against him, or the other prong of assisting in his defense in a rational manner. Just so the record's clear, Judge, we have spent, I will say, at least point hours with Mr. McCall, both live, in person, on Zoom, through various written communications, and I do not believe that he falls into either of those prongs. I believe he is absolutely understanding the nature and object of the proceedings, and that he is able to assist in his defense in a rational manner. I just want to make that record clear so we do have a record of our position.
Mr. Angot cited the appropriate court rule. I was addressing as terms of statutory authority that the court has. It's 330.2024, which indicates that the issue of competence to stand trial may be raised by defense, court, or prosecution. The court here in this case has raised the issue of competence on its own motion. Neither defense nor prosecutor has made that motion, and obviously Mr. Angot here arguing against the court doing what it has done today. But I think Mr. Angot does also cite the appropriate statute with regards to the two-prong test here for the court to consider. And the court made its record.
Here the judge lays out the legal framework very clearly. Competency isn't about whether someone is guilty or innocent. It's about two things only. Do they understand the nature of the trial? And can they rationally assist their lawyers in their defense? Even the defense attorneys argue that McCall does meet those standards, which makes this a rare situation where the judge is raising the competency issue on his own.
Here's the court's reading on this. I agree with Mr. Angot. The letter from Mr. Nadeau does indicate that Mr. McCall is neither a threat to himself or others. There's also been this. The tether dates back to March 26th. Mr. McCall has not had any violations of the tether provision for all of that period of time. The concerns that the court brought up here today have been present throughout because in part the court based its ruling on communications that Mr. McCall has sent throughout that period of time. Mr. McCall is apparently treating with Mr. Nadeau in addition to others. I don't see a basis right now to continue on with the tether. So I'm going to amend the bond conditions to remove the tether. However, I'm going to alter some of the other specifics of the conditions of bond. So in lieu of the tether, I'm ordering weekly phone check-ins with pretrial services. I'd like also monthly updates of ongoing mental health treatment that Mr. McCall is engaged in, both with Mr. Nadeau And he's mentioned 2 other doctors now to this court on 2 separate occasions. So I'd like continuing updates from those additional doctors if he's treating with them. They should.
And then, interestingly, the judge makes a decision that partially favors McCall. The court removes the electronic tether that had been monitoring him for months. But instead, the judge replaces it with weekly check-ins and ongoing mental health updates. So while the competency evaluation moves forward, the court is also loosening some of the restrictions on McCall while the case continues.